What kind of jurisdiction here?
Personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
This court, as well as the state, lacks personal jurisdiction. I'm simply here under threatened arrest or coercion of you, saying that you would hope put out a bench warrant for my arrest. The subject matter, in regards to the name as well as the vessel that was used, is again under conveyed and is held and protected within the trust. And according to Article 1, Section 10, Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly properly functioning at this time. So with that.
All right. So here's what we'll do, because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong. Because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan.
This sovereign citizen came into court convinced that a trust, constitutional clauses, and jurisdiction arguments would make the entire case disappear. But when he finally lays out his theory, the judge doesn't hesitate for a second. What happens next completely changes the tone of the hearing, and it's the moment where the judge makes it crystal clear that these arguments aren't going anywhere.
Already, Judge. Courtroom Feaster, Assistant Public Defender, on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office to represent me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
Is this going to be a Bellinger's thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had enough counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here. So I don't know what's going on, Your Honor.
No.
Mr. Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this.
You're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no way I can.
In a vehicle with a hat on, no mask. Oh,
I am inside my vehicle right now.
What'd you say?
I said yes, because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital starting the COVID diagnosis?
Excuse me?
All right, guys, this hearing starts off unusual almost immediately. Before the court can even get into the actual criminal charge, the defendant rejects his court-appointed attorney, insists on defending himself, and begins challenging the court's authority. What follows is a constant battle between someone trying to control the courtroom conversation and a judge who has absolutely no patience for legal buzzwords, jurisdiction claims, or procedural games. And the deeper this hearing goes, the more obvious it becomes that these arguments are heading toward a collision course with reality.
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're going to do. Then I'm going to say, okay, you've got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're going to represent yourself.
I can't make that. Is there a later date?
Oh, yeah, you can. 3 o'clock.
3:30, I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then
okay. And at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See
didn't
you at
have.
3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line.
Right away, you can feel the tension building. Most defendants spend these early moments trying to avoid problems. Instead, this defendant immediately starts creating new ones. The judge is simply trying to figure out who is representing him and how the case will proceed. But every answer seems to create another argument. And when the defendant casually throws out the claim that the court has no jurisdiction, that's the first sign of where this hearing is headed. Because the judge has heard these arguments before, and he's clearly not interested in entertaining them.
Mr. Canatra, Senior Assistant Prosecuting Attorney for the People.
What's your name?
Tariq Samar Tariq, the executive of the Tariq Samar Tariq Living Trust. Glad owner Tariq Wilson Estate.
Sir, you indicated that you wish to represent yourself on this matter.
Yes.
All right, you understand at your arraignment, you were given the charges that were filed, have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding,
Fleeing and eluding third degree.
third degree, correct. And if anything else was tallied onto that, then I was not told.
Okay. I have one charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
I do, but I have some questions.
Well, as soon as I get through this, you have indicated that you wish to represent yourself. I advise you that there are some dangers in you representing yourself. You understand that, sir?
I do comprehend.
And you understand that if you proceed to represent yourself, that the court is not going to assist you to understand the procedures or anything regarding the court proceeding, that you will be responsible for that, and I will be holding you to the same standard that I would be holding the attorneys in the room in terms of even ruling on evidence or anything along those lines in regard to the procedure and the process. Understand that, sir?
Correct. I comprehend.
All right. You also, so I will ask you again, do you still continue to wish to represent yourself in this matter?
Yes, I will be defending myself.
You understand also, sir, that should you change your mind and could not afford to hire an attorney and wish to be represented by an attorney, the court would consider making sure that you are afforded counsel. You understand that?
I comprehend.
This is where the hearing takes a dramatic turn. Instead of focusing on the actual criminal charge, the defendant starts introducing theories about trusts, ownership structures, constitutional interpretations, and why he believes the court lacks authority over him. The problem is that none of these arguments address the immediate purpose of the hearing.
How do you wish to proceed on this matter, sir?
First, I wanted like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of a personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party, Wall Street Towing, and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser, with the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust. Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust, and I'll be able to supply you all with the adequate assurance certificate of security to settle and offset the charges.
Okay. Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing,
This is a probable cause hearing.
so I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it.
You can hear the judge trying to separate legal procedure from irrelevant claims. And when the defendant attempts to involve the judge and court staff in his own trust-related theories, the judge shuts that idea down instantly. At this point, the courtroom isn't debating facts anymore, it's debating reality itself.
I never pleaded demur. There was
You stood mute, you stood demure. You don't even know what that means. You're just using words and have no concept
No.
as to what they mean.
demur and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not, they are not,
No need to.
they are not,
I'm not here.
they are virtually the same thing. So where do you wish to proceed now?
As I stated, my
Do
motion,
you wish this set for preliminary examination? Your motions have been
I
denied.
wish to provide the evidence that any of this needs.
You
to-
don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing to have discovery.
Discovery should be provided regardless. There's no wish about
Do
it.
you wish to have
Discovery should be
discovery?
provided.
Don't play word games with me.
I'm not playing.
Mr. Allen,
Discovery,
not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
This is where everything starts unraveling. The judge is asking straightforward procedural questions, but instead of giving straightforward answers, the defendant keeps redirecting the conversation into legal phrases and technical language. The tension rises because the judge recognizes something important. The defendant is talking a lot without actually moving the case forward. Then comes the warning. And whenever a judge starts warning someone about word games, it's usually a sign that patience is running out very quickly.
Yes.
Do we have copies of discovery available that can be provided to this defendant?
No, Your Honor, I know that the PD was representing this individual. I don't have copies right now.
I got you. Okay. So are there copies of the police report as well as other discovery that's in the hands of the public defender's office?
I do see traffic stops and discovery videos onto our program.
All
We
right.
have documents.
All right. Those need to be gotten to the defendant. How soon can those be gotten to the defendant?
I can get those in hopefully by tomorrow around.
You have an address for him to send those to him.
Yes, I do. I can confirm it with him too.
All right. What do you have as the address? Do you have an address on, is it share?
I do, Your Honor.
Okay.
Horrible.
Okay, gotcha. All right, you'll make sure that that is sent to him.
What's interesting here is that the judge keeps offering the defendant exactly what he says he wants: evidence, discovery, police reports, case materials. But instead of simply accepting those tools and preparing a defense, the defendant continues arguing broader theories about crime, injury, and government authority. The judge eventually cuts through the confusion and forces the conversation back onto practical matters. Because regardless of someone's personal beliefs, criminal cases still move through established procedures. and the court is making it very clear that this case will be no exception.
You also have an email address so that all things can be emailed to him also.
I do, Your Honor.
All right. Very good. Sir, did you wish to then have another PCC, or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing,
What kind of jurisdiction here?
personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
This court, as well as the state, lacks personal jurisdiction. I'm simply here under threatened arrest or coercion of you, saying that you would help put out a bench warrant for my arrest. The subject matter, in regards to the name as well as the vessel that was used, is again under. It was conveyed and is held and protected within the trust. And according to Article 1, Section 10, and Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly and the trust is properly functioning at this time. So with that,
All right. So here's what we'll do because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in because you're wrong. So we might as well get it in writing that you're wrong. Because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
awesome. So that would be the next step. And I can get those in today.
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
Yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine. And then I will file the proper documents for it.
This is the moment the entire hearing has been building toward. The defendant finally presents what appears to be his central argument, that the court lacks authority over him because of trust-related legal theories and constitutional protections. The judge listens, lets him finish, and then delivers a response that couldn't be clearer. The judge flatly states that both personal and subject matter jurisdiction exist and tells him to put any objections in writing. That's a devastating moment because the argument that was supposed to stop the case doesn't stop anything at all. The hearing simply moves forward.
The jurisdictional hearing. Gotcha.
So I'll adjourn the probable cause conference in this case, April 25th, 2024 at 3 p.m.
Is it possible to get another week
in person.
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I was on the call. I've heard you give multiple counsels extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable.
setting the date
So,
of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PC, to a preliminary examination.
By this point, frustration is showing on both sides. The judge sets a future date and explains that the defendant has enough time to file whatever motions he wants. But when the schedule isn't exactly what the defendant requested, the conversation immediately shifts into accusations of bias. That's another turning point. Because instead of gaining ground, each objection seems to reinforce the judge's decision to keep the case moving. And the final claim that he's acting under threat and coercion doesn't change the outcome either. The hearing ends exactly where it was always going to end, with the case continuing forward and the defendant being told to put his arguments on paper.
just for the record, I put it on the record that I object. But under threat, direction, or coercion, again,
Your objection is noted.
right, and under threat and direction, coercion, I'll be here.
Is there anything else?
I said what I need to say.
Anything else from the people?
No, Your Honor, thank you.
Bond will continue.
Am I waiting for paperwork or get it from the front?
Pardon?
Am I waiting for paperwork regarding the next?
No, you may leave.
Oh, is it being mailed, or I'm trying to figure out how do I get the paperwork?
You can check out at the front counter.
Okay, thank you. That's all right.
That it for me, Ann?
Yes, sir.
Thank you, everyone. 14A stands adjourned. Take me off, please.
This hearing is a perfect example of what happens when courtroom procedure collides with unconventional legal theories. The defendant clearly believed his jurisdiction arguments would fundamentally challenge the case. The judge, meanwhile, focused on one thing: keeping the process moving according to the law and court rules. No matter how many constitutional references, trust arguments, or objections were raised, the case itself never stopped moving forward. Do you think the judge handled this hearing correctly, or should the defendant have been given more room to argue his jurisdiction claims? Let me know in the comments below, and subscribe for more real courtroom drama and legal breakdowns.